Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today I want to talk a little bit about one of the banes of the appellate lawyer's existence, called page limitations, and how that flows into how I do my job. I don't know if this will be interesting to you, but it's something that I think I just need to talk about, maybe. I don't know. So, lawyers as a general group have this terrible habit of never getting to the point. If you go in and you ask a lawyer a question, should I sign this contract? You'll rarely get a straight yes or no. What you'll get is something to the effect of, well, you have to make that decision, but let me tell you what the risks are. And basically, instead of saying, I wouldn't sign this contract, and here's why, they give you all the options, and as a result, you're much better informed, but sometimes it takes a lot longer to get to the point than maybe it should have. That's just a function of how lawyers operate. And it's especially bad in writing, because a lawyer will write something to death. Only a lawyer drafts a document that is 115 pages long and calls it a brief. As a result of this failure to get to the point, courts impose either page limitations or word limitations. Now, in the appellate courts, particularly in the state and federal appellate courts, there are word limitations. Your brief may be limited to 40,000 words. In the district courts and circuit courts, you have a limitation based on the number of pages. You have to get your document in within 15 or 20 or 25 pages. And some motions, of course, are allowed to be longer. For example, a motion for summary judgment has a requirement that you put in a statement of facts and with it all of the supporting documentation that goes with it. So the factual statement in a motion for summary judgment can go on for 40, 50 pages without any problem at all. But the argument portion of it is usually limited to somewhere between 15 and 30 pages. And in a very complex case, that is a very difficult hurdle to get over. With that understanding, let me tell you a little something about some of the things that happen in an average day for me when I'm working on cases. I'll get a motion in that has been put together initially by someone else. So I will look at the things and I will shore up some of the authority and send it back to them. And after I send this 34-page document back to them, they send it back and say, oh, no, it has to be 15 pages. The judge has a 15-page limit. And so, you know what I'm thinking, right? Which is, why did you write 34 pages when you only had 15? But my job in that situation is to cut the thing down to 15 pages. So you would think that that'd be a pretty hard job, but it's not as difficult as it sounds, again, because lawyers have these predetermined fantasies that things need to go a certain way, and they really don't. For example, the first 5 pages of that document were all about the legal rules that apply in that particular kind of motion. This rule applies, and that rule applies, and another rule applies, and then this is the case law that interprets the rule, and this is the Seventh Circuit, this is the Eastern District, this is the Seventh Circuit, and this is the Supreme Court. This is how they all flow into all of these rules. And I look at that and I think, okay, you've got a judge who's got a 15-page limit. He's got it for a reason. And the reason that he has this 15-page limit is because people can't get to the darn point. And that's what he's trying to make them do. He's trying to focus them on the real issues in their motion or their hearing request, whatever it is. The judge wants it focused. He wants argument that is directly related to the issues involved, and when you tell him what all the rules are, that's like going to the doctor and telling him what the thoracic cavity does. I mean, I think he knows. And the judge certainly knows and certainly understands the rules. He gets 100 of these motions a month, probably more than that. And in every one, he starts with, okay, here are the rules. He knows the rules. But for some silly reason, lawyers think they have to tell the judge, the guy who actually writes some of the cases that they later rely on, you have to tell him what the rules are. But they don't. Not really. So with that general understanding, the first 5 pages were cut down to about 1.5. And then I went to the first point that they wanted to make in that motion, and I made that in about 4 pages. And I did that by cutting out all of the case law, except for the points that were really, really important to that particular issue, and then honing and focusing the writing. There are so many things that people get used to writing that don't matter. And as a result of that, it can sometimes be really annoying to read what could be a 5-word sentence, Dr. Jones is not a qualified expert, and instead read, based on the review of his report and the case law as cited above, and his failure to document his review based on the methodologies that he employed, it is clear that Dr. Jones is not a qualified expert. Well, why don't you say the first part, the important part first? He's not a qualified expert. Here's why. And that's just because when lawyers write, when a lot of lawyers write, they write basically the way they would talk. And they sort of picture themselves up at the podium telling the judge these things. And because these things are important to them, they think necessarily that they'll be important to the judge. Whereas what the judge wants to do is get to the point. So again, I get to the point. Now that goes against the way that we are taught to write in law school. In law school, we're taught issue, rule, analysis, conclusion. They call it the IRAC method. The issue is whether Dr. Jones is an expert. The rule is that Rule 702 applies, and here's all the stuff from Rule 702. And Rule 702 says this, and the Seventh Circuit says this, and the Supreme Court says this. Now let's get to the analysis. Okay, based on the facts, these are these are the reasons why he's not qualified. And then at the end, Dr. Jones is not a qualified expert. That's the conclusion. Well, that's fine. If that's the reason, if that's the conclusion, move it to the top and then support it. Don't leave it down there at the bottom. The way you're writing, the way these people write, which is to fluff a lot of stuff in there, the judge isn't even going to make it to the conclusion. He's going to say, what's the point? Where's the beef, so to speak? So I usually start with conclusion, analysis. You know the rules, judge, and this is what needs to be done. So I have conclusion at the top and the bottom of that kind of argument. And I think that's important because a lot of times lawyers just lose sight of the fact that they're talking to someone who knows at least as much about the law as they do and is responsible for getting it right. And so you can't lose sight of that when you're talking to a judge, but many lawyers actually do. If you want to learn how not to write, you can learn a lot about how not to write by going into any circuit court and asking for random cases to be pulled and reading some of the briefs in there. Because some of those briefs will ramble on for paragraph after paragraph without ever reaching a point. So one of the things that somebody asked me once is, how many pages a day do you write? Well, I usually average, when I'm working on a brief, I will average between 20 and 30 pages a day. Now that sounds like a lot of writing, and to a certain extent it is, but a lot of it is not me doing the writing. A lot of that is me using the Command-C and Command-V keys on my keyboard to cut and paste arguments usually from cases. And that process works quite well to reduce the amount of time that I have to work. But I have to be careful to include only that part that really matters. Because again, just as lawyers say a lot of things that don't really matter in the long term, sometimes so do courts. So a lot of what I do is cutting stuff down into short declarative sentences. Dr. Jones is not a qualified expert. And a lot of times that's all that's really needed to distill a brief down to the point where it really is brief. So it can be very frustrating then when you send that back to someone and they go, well, you've just chopped this all up. I don't think we can use this. And maybe they can't. I don't know. But I can tell you this much. If you go and you ask for an extension on the page limitation, a lot of judges are going to tell you no. And the reason they're going to tell you no is because you never get to the point. So I think this is something that's valuable to people who do other kinds of work. If you routinely write reports or anything like that for your company, or if you just write for pleasure, and I know there are people out there who are going, you mean there are idiots out there who write for pleasure? It's true, we do. If you write for pleasure, just learn to get to the point first and fill in the analysis at the end. Because a lot of people want to know the end result. One of the things that I have to tell you, I'm a little bit of a chef in training, I guess. I love to cook. My wife loves to let me cook. She sometimes doesn't like cleaning up after me, but I tell her I'd clean up. But she says, no, you cooked, I'll clean. But one of the things that drives me absolutely nuts is if you go and you look at, you try to find a recipe on the internet. I want to make cherry clafouti, right? So what you do is you find a place where that recipe pops up and you go to look at it. And you learn that this person went to France in 1995. They wandered through the vineyards. They got to speak to a French chef. The French chef explained all of the things that go into making a pudding, and that this cherry clafouti is a lot like a pudding, blah, 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 blah. And then at the very bottom, after you've waded through about 500 words worth of text that you never really needed to know to make cherry clafouti, there at the end, there is your recipe. It drives me nuts. Put the recipe at the top. Tell me about your travels later. I'm trying to cook. I'm not interested in reading your stuff. Gosh, this sounds like a rant today, and it's completely I guess it isn't completely non-legal, but it is somewhat non-legal. But lawyers have lives too. If anybody would be interested, let me know if you would like to see a day in the life video for me. Because I don't work full time in the law. I spend several hours a day doing this. So I have a little bit of a different way that I go about working, and that's something I've thought about maybe doing. Let me know in the comments if you think that might be a good idea. So thank you very much for watching. I appreciate your attention. I appreciate you letting me ramble today on this. And if you have the opportunity today, do something to fight hunger in your neighborhood. Whether that's by giving money to your church, giving something to the food pantry, just do something to help people who are hungry. It is not a pleasant situation to be in when you don't have enough food to feed your family, and you are responsible for feeding that family. So if you can help out, please help out. And if you need help, remember, local churches are probably one of the first places to go to get some of that help. Thanks for watching. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.